Good morning. Thank you. It's a pleasure being here. As I said, you were going to meet John Letizia, and for those of you who've heard him speak, he's a lot of fun, and he talks about a lot of things and has a lot of war stories. I'm going to give you some examples from my own experience as well, and I appreciate you allowing me to be here today, and John sends his regrets. So you may be wondering, why do we have to talk about the pandemic, right? We think we're heading out of the pandemic, communities are opening up, workplaces are opening up, things are changing. But, 2 years into the pandemic, employers have faced changing and sometimes conflicting guidance from the state and federal governments, from regulatory authorities, and others on workplace safety issues related to the pandemic. I mean, do they wear masks? Do we mandate masks? Do we not? Do we vaccinate? Do we not? Do we mandate it in the workplace? Do we not? And amid all of this sometimes confusion and changing landscape that employers are facing, employers still have a very important duty to provide a safe workplace for their employees under the General Duty Clause of the Occupational Safety Health Act. And it's something that employers don't always think about because they're so busy trying to comply with and understand the current executive order and guidance that might be issued by the prevailing regulatory authority that governs all of you and the work that you do. But you need to think about this OSHA General Duty Clause because it is so broad and because it governs the safety of your employees in the workplace. And the workplace is also defined very broadly as where they work. So it could be outside of your physical proximity of your particular office or manufacturing company, but in the workplace in which an employee works. So again, it's something we need to keep in mind. And we're going to review some of what this means for employers and go over some of the issues that still remain in terms of trying to maintain a safe workplace for your employees. So OSHA's General Duty Clause. The General Duty Clause is in the Occupational Safety and Health Act, and it requires employers to furnish each employee with employment and a place of employment which is free from recognized hazards that are causing or likely to cause death or serious harm. And so the question is, well, what is that and what is it, when is it used? Well, OSHA uses that in its inspections of workplaces when there is no other specific standard governing your workplace. Most of you as employers may have other specific OSHA standards that you spend a lot of time thinking about and worrying about and ensuring that you're compliant with those requirements. But at the end of the day, there is this General Duty Clause that OSHA cites to and invokes when there are workplace safety issues that aren't otherwise covered by other standards. And so the following elements are necessary to prove a violation of the General Duty Clause. And one, it's that the employer failed to keep the workplace free of a hazard to which the employees of that employer were exposed. The hazard was recognized by the employer. The hazard was causing or likely to cause death or serious harm. And it was feasible and for the employer to basically correct the hazard. And the COVID-19 illness and virus is in fact a recognized workplace hazard that employers are obligated to take steps to implement protections to ensure that that hazard is mitigated in the workplace and that risk to employees is mitigated in the workplace. What is a hazard? Well, a workplace hazard is something that an employer either knew or should have known existed in the workplace, either due to the fact that there were previous incidents in the workplace, because of employee complaints, because of previous failures to correct a particular incident or hazard in the workplace, industry standards, and also information that's available to an employer. And that would sort of encompass the COVID-19 virus and the fact that, again, we're operating in this very different and unusual time in our history, and employers have to take into account the fact that this is still out there and still exists. And the question is this a hazard to my workplace, and what can I do to address it and to mitigate the risk of that hazard? So again, although courts may like OSHA to invoke specific standards when those standards exist to govern your workplace, the general duty clause exists and is invoked and is in fact endorsed to be used in this context, particularly with, again, COVID-19. President Biden has given OSHA a lot of authority in this regard, and even though there's a whole lot of uncertainty about vaccine mandates and everything, and OSHA's actions with respect to all of that have kind of gone by the wayside, OSHA has made a point of making it clear in published guidance and elsewhere that it is going to use the general duty clause to protect the workplace in response to employee complaints. So employers need to understand what their obligations are there. And in fact, that duty is enforced with civil penalties, the right to injunctive relief that OSHA has to seek against a particular employer. But those sanctions, the civil monetary sanctions, are extensive, and they can be anywhere from 5 figures to 6 figures, depending on the nature of the violation, what the employer knew, did the employer try to mitigate a risk once he found out about it, and so forth. It is also fairly clear, though, that employees cannot sue employers for things that are prohibited under OSHA. And so courts often dismiss cases that are brought by employees against employers for alleging, for example, the failure to protect them from COVID-19. Based on what's called OSHA's primary jurisdiction. So that you may have seen in the press, there's a lot of cases that employees have now been trying to file. A group of workers in New Jersey suing Amazon, and other employees trying to sue their employers, claiming that their employers failed to keep us safe during the pandemic. Courts generally are rejecting those claims, saying that OSHA has the primary responsibility to address workplaces, and that it is therefore OSHA's primary jurisdiction to address this. But it doesn't mean that an employee or group of employees can't bring an action and can lead to some very expensive litigation to try to get an action dismissed. And in fact, in a case that's actually quite interesting and a little concerning for employers that was brought earlier this year, an employee brought a lawsuit against her employer arising out of not the fact that she contracted COVID, but that her husband contracted COVID from her. And so that was a negligence claim brought against an employer arising out of a spouse's death from COVID. And although it's California, and California recognizes a lot of causes of action and theories that other states don't, it's sort of thought to be the first of its kind in the nation, and we're all kind of watching to see what happens, but the court did not decline to hear the case and allowed the case to proceed, at least in the early stages. So that's something that we need to keep an eye on, and gives you some sense of the potential scope of liability that is out there. So again, the general duty clause, again, there's nothing really specific to covering exposure to COVID-19, but OSHA has other standards in place governing, for example, the use of personal protective equipment that may apply in cases where your employees are required to use eye, face, hand, or respiratory protection against COVID exposure. So where those standards apply to you and have some applicability to COVID-19 and the virus and exposure to the virus in the workplace, OSHA may use those requirements and standards in an investigation of your workplace. Now again, OSHA has provided guidance on protecting workers during the COVID-19 pandemic. And that guidance is really general guidance used to address general issues in most workplaces. And again, it has suggested that there be, again, a process in place to facilitate employees getting vaccinated, instructing employees who are infected or unvaccinated employees who've had close contacts with someone who's tested positive to stay home and stay out of the workplace to prevent the risk of transmission in the workplace. Also, implementing physical distancing is something that OSHA has recommended, particularly in those communal workplace areas where unvaccinated and other employees or visitors from the outside congregate with each other. OSHA's recommending providing face coverings to employees or surgical masks as appropriate, unless your workplace requires a respirator or some other more specific type of PPE. Again, the recommendation that you educate and train employees on your policies and procedures using, again, accessible formats and languages they understand. Now, policies are important because if you are facing an OSHA investigation, it's in response to an employee complaint that the workplace is unsafe. We don't wash our hands enough, we don't wear masks, and we should wear masks. An employee complaint can be based on anything. The amount of disinfection that you use in your workplace, the type of masks that employees are provided, it can be based on anything. And so having a policy in place that identifies the expectations in light of COVID-19 is really important, because if OSHA walks in and investigates based on an employee complaint, you can say, well, here's my policy. I have a policy, we've implemented it, employees are aware of it, and I've trained my managers on how to make sure that we're implementing it. Now, those are important, but it's also important to know that if you're going to have a policy, you have to follow it, which is also important. And we will talk about some of the things that employers and workplaces have policies on now. But OSHA also suggests or requires that unvaccinated customers, visitors, guests from outside of a workplace wear face coverings in public-facing environments, so such as banks, retail establishments, so that people are safe generally. Maintaining ventilation systems is also something that's recommended by OSHA. And of course, performing routine cleaning and disinfection. So any of these items could lead to an employee complaint. And of course, employee complaints are often anonymous to OSHA. They're basically lodged either in writing or, telephone complaint. And OSHA will take that complaint, potentially, usually, inform the employer of the complaint, and then ask for information in response to the complaint. And one of the things they're going to ask for would be your policies. For example, if the complaint relates to social distancing in a very small manufacturing environment, which is a complaint that I've dealt with, OSHA will say, to the employer, we've received a complaint regarding your social distancing. I'm giving you 10 days to give me all of the following information in response to that complaint, including your policies, your communications with employees regarding social distancing and other COVID-19 measures that you're taking to protect employees in the workplace, and so forth. And so OSHA is going to take that information, it's going to review it. It may decide it needs to come in and investigate your workplace, observe your workplace. Sometimes, just based on the receipt of information from an employer and a detailed response that has to be carefully crafted. That may be the end of the OSHA investigation. But again, having a policy is important. And so again, whether that policy is on work exposures to COVID-19, what to do if an employee comes to the workplace sick with COVID, or other employees have worked in close proximity to an employee who is now tested positive for COVID. Employee screening measures. Many employers have those measures in place, but they should be written in a policy so everybody knows what they are. And by screening, I mean, do you require your employees to take their temperature in the morning or to report specific symptoms and stay home if they have certain symptoms? What you do when you, again, find out somebody's tested positive. Do you require vaccinations? Do you require masking? Do you require third parties who come into your workplace to mask or to be vaccinated? Those are some of the things that a policy for your workplace can address, and again, will help you in the ultimate end game, of course, first to make employees aware of what the rules are and third parties, but also to be able to demonstrate to OSHA that you've taken this workplace threat seriously. So in addition to having policies in place, and in addition to these items that OSHA has recommended that employers address and consider, there's also the obligations that employers have to both record and report workplace exposures to all kinds of hazards, but including COVID-19. And again, that's important to keep in mind. What's also important, and I'm going to spend a little more time talking about it, is to have protections in place from retaliation against those employees who make complaints in the workplace about workplace hazards. So with respect to COVID, it could be something like, boy, I'm a little nervous being in this lunchroom. There's about 15 of us in this really small room. It could just be an employee saying something to somebody else. It could be something like, we don't have enough disinfection. We ran out of Purell 6 months ago. It could be anything. And so you have to implement, as a policy again, protections from retaliation and set up an anonymous process so that employees can voice concerns about workplace hazards, and including the COVID-19 related hazards. And again, you know, the OSHA Act itself prohibits discouraging or in any way impairing or discriminating against anybody for engaging in occupational safety and health activities. And those occupational and safety health activities include making a complaint about a workplace safety issue. So even the most innocuous things that sometimes you don't even perceive as a complaint could be a complaint. And so it's important to have a policy in place or ensure that your workplace has some kind of a policy in place that protects people and says that you prohibit retaliation for making workplace and safety complaints and expressing those concerns. Your policy should also address how those complaints, the employee complaints about workplace safety, are addressed. Who do they report it to? Should it be addressed to HR? Should it be addressed to a supervisor? Again, encouraging the report of health and safety issues in the workplace. Whether it's, you know, a manufacturing company that works on machines and it's a safety issue with respect to the use of a machine, or is it something related now with the overlay of COVID-19? We don't have enough wipes and Purell in the workplace, and that's making me nervous about coming into the workplace. That's still a workplace complaint. And you want to have a way that employees can anonymously and comfortably express those kinds of concerns and safety issues in the workplace. In addition, you want to have in your policy how actual workplace accidents and injuries are actually reported, to whom are they reported, and when should they be reported. Presumably as soon as possible, but some, employers have specific requirements on that, and OSHA has standards on various aspects of that. It's also important to train your supervisory employees to take complaints seriously, or to listen to what employees are saying, because they may actually be a complaint. That's, again, hard to recognize. But to take a complaint and a comment about safety issues seriously and respond to it appropriately, whether it's to tell human resources, tell the president of the company, tell the vice president, whatever mechanism is in place, whatever process you want them to follow, you want to make sure that that is known to your employees. And again, another important piece is that any workplace and safety complaints are investigated confidentially, and you want to make sure that employees know that their complaints will be investigated confidentially. So the next slide talks about how OSHA retaliation claims can really arise out of what are seemingly innocuous and harmless statements about workplace safety issues. Again, as I'd indicated before, OSHA's looking at this general duty clause and is enforcing workplace safety issues surrounding COVID by invoking that clause. But it's also taking a closer look and responding now more than ever to employee retaliation claims. And retaliation is when an employee believes that he or she has suffered some kind of unfavorable consequence, personnel action at work. Maybe the employee's hours are cut, maybe the employee is disciplined, maybe the employee loses some PTO time, or is demoted, or otherwise isn't considered for a promotion that the employee feels the employee is entitled to and should receive. In response to a complaint about workplace safety issues. So again, sometimes these workplace safety complaints occur in circumstances that you don't even perceive as a complaint. It's not only in response to an actual complaint to OSHA, but when an employee says something to you as the president of the company, or to his supervisor, or to a coworker that the employee somehow thinks is a workplace safety complaint. And so, again, it can be anything, and it's also important to know that the definition of workplace is really broad and encompasses where the employee works. So the employee who is installing carpet, for example, in a business, has some concerns about his work conditions there. Maybe it's a really small building, maybe no one's wearing masks, maybe the people who work there just had a COVID exposure and he finds out about it when you send him there to install a rug and he doesn't want to do it. That's a complaint and a concern about a workplace safety issue. And it's important to be aware of that, to take the question and the issue into consideration, to investigate the issue and try to respond to it. Because again, the employee who feels like they are not being responded to in that regard could file the OSHA claim. And if something happens in the terms and conditions of their employment, again, we went over some of those things and what they could be, whether it's demotion, promotion, maybe he's just a bad performer. But at the end of the day, employees will claim that the bad thing that happened to them at work was in retaliation for their complaint about workplace safety. So when OSHA gets a retaliation complaint by an employee, again, a second wholly different kind of complaint from your typical workplace safety issue. This is, I've been retaliated against because I complained. OSHA comes in and sends an employer this enormous list of documents and information that it needs to assess the employee's claims, including information about your operations, about your prior personnel action with respect to other employees who are similarly situated to this employee. They'll ask for your policies, your practices, and a variety of other information from you to assess the employee's claim. And employees often use this information gathering process, particularly if they are represented by an attorney, as a way to do some free investigation into the employer, to use it as a springboard for another type of claim against the employer, including an employment discrimination claim, a discrimination claim based on sex, based on race, based on age, and so forth. So it is what we call free discovery, if you will, into an employer's processes and policies, and it is actually a really, really burdensome and intrusive investigation. And so what's important is to be able to respond to it in an organized and detailed fashion to try to limit the areas of inquiry and the employee's ability to use it against you in other litigation. And again, employers who have found to have retaliated against employees for engaging in this protected activity can be required by OSHA to reinstate the employee, to pay back wages, restore benefits, or provide other money damages to the employee. Again, it's also important to note that since the pandemic has started, there's been an increase in this kind of civil litigation and wrongful termination type litigation, alleging that an employee was terminated because they reported something to the employer about workplace safety. So we've also included in the outline some guidance that the AFLCIO is providing its members on OSHA and COVID-19. It's just some bullet points about what the AFLCIO and how it's interpreted what employers are supposed to do under OSHA. And so, you know, again, hand washing access, respirators when those are required, what that particular organization requires of its employers, fit testing, training on the use of respirators, including why that's necessary and the limitations on the respirator and otherwise. So we included that so that you can understand that they too have issued some guidance in this regard. In addition, it's important to know too that OSHA, there's a number of areas that OSHA hasn't issued any standards on. So, and one of those places I wanted to focus on, of course, they talk about indoor air quality, but also workplace violence. I mean, that's something that's actually in recent years really generated a lot of OSHA complaints, and then by then retaliation claims. A recent case comes to mind where we represented an employer because an employee alleged workplace violence and filed a complaint with OSHA when a coworker slapped a cell phone out of her hand because she was trying to take his picture and he didn't want his picture taken. But at the end of the day, she alleged workplace violence. So OSHA came in and investigated, asked for all kinds of policies, procedures, processes regarding how the employer addresses workplace violence and so forth. And that then, of course, she was a poor performer and was on a performance improvement plan. So of course, the discipline that resulted from her complaint of workplace violence, the discipline that was ongoing before her complaint of workplace violence also led her to create a claim for retaliation. And it was a 2-year investigation, you know, into the employee's claims, both of workplace violence and retaliation. But there are a number of things that OSHA has not developed standards to address, and therefore the general duty clause applies. Just to sort of close, because I know we're out of time, there's some examples on this next slide of examples of hazardous situations, again, wholly outside of COVID, where employers were cited under the general duty clause and ordered by OSHA to, remediate the hazards identified. And that's even repeated lifting above the shoulder height, having no immediate means to summon medical aid or assistance while working alone, a conveyor system with no functioning emergency stop devices, standing for long periods of time without adequate support. Again, something for which OSHA has come in and actually ordered the employee to fix the situation. Finally, we included something about weapons in the workplace, only just for FYI that OSHA has declined to implement a specific standard with respect to firearms in the workplace. Again, it's another issue that could be addressed under the general duty clause. But OSHA has deferred to state federal law to address the issue of weapons in the workplace. And certainly you as employers are entitled to, implement policies to prevent that type of conduct. So again, even if there's no specific standard in place, an employer has to consider the general duty clause in thinking about what it can do to protect its employees in their work and in their workplaces, wherever they are. And at the end of the day, even COVID-19 is a workplace hazard that employers have to keep in mind, even at this stage of the pandemic, when we're talking about additional boosters and additional variants and so forth. We're not done, and employers do need to consider keeping their workplaces safe. So thank you very much. I'm happy to answer questions, or I can stay and answer questions after, because I know we're running a little behind.
We have time for one question, unfortunately, please. Lunch is approaching rapidly.
It's lunchtime, I know.
Yes,
that's
so. One
so.
over there. Thanks.
Hi, I'm just wondering, what factors would you use to be able to identify whether a case of COVID is work-related, quote unquote?
That's its own seminar. That is so hard. It really is. And we've asked OSHA about this too, just for purposes of reporting and documenting and recording, and you cannot get an answer. But again, it's the temporal relationship. It is, to me, a lot harder to say it is related to work when you're not even in the business of dealing with that. Healthcare providers have a much different, I think, ability to make that relationship than to most anybody else. I mean, you can get COVID at Stop and Shop, so it's really hard to say someone got it at work. I can provide, there is some little bit of guidance that OSHA has published, and I'm happy to give that to CBIA, and they can circulate it, that gives some sense. It's a multifactorial analysis, but temporal relationship, when the person became symptomatic, when was the exposure, and it's hard to say it was at work. Again, if you know you have an employee at work with COVID, you send the employee home, you've done what you need to do there, and this employee works with that employee, that might be a factor that leads in favor of finding it work-related. But, to have somebody in a different department or a different, shift somehow come down with COVID and say it's work-related for purposes of the OSHA obligations, it's a little harder, very hard to do.